Thank you. So, I mean, if the United States is not your primary one, it should not affect your application totally. So, thank you, Anton, and let's move to our final speaker. His name is Dmitry Gladkov, and Dmitry Gladkov is a partner at the Transaction Advisory Group. And I would say that that company is also one of the organizers of our webinar, and I want to say thanks a lot to Dmitry helping us to organize this, to become a partner of this event. And he will speak not about the IP issues, but he will speak maybe about something that is more even important than IP. He will speak about the corporate structure of the company. What should it be like? What is the best one if you want to go to United States? And it is very actual to any company, even not an IT company. So, Dmitry.
Dmitry, thank you very much. And ladies and gentlemen, thank you for joining our conference. Let me switch on my presentation. Here it goes. Okay. My presentation, I would like to you view it mostly as a teaser, and which will raise your awareness of certain issues when you are moving your business to the United States. And when I say teaser, because we are going to set up a series of conferences with the same sponsors, and during these conferences, we will discuss all the corporate issues, tax issues, regulatory of establishing businesses in the United States. So stand by and wait for our invitations for the coming conferences. So now back to my presentation. Our practice have some experience of moving 5 or 6 Russian companies to US over the last several years, and every project, every migration project was quite unique. But anyway, when you do structuring work, structuring analysis for every of those projects, you come across with all the same issues. So most of these projects have some common points, which I would like to reflect in my presentation, and now you see them. First point is direct or indirect ownership. Russian business likes to have parents and shareholders somewhere in offshore companies. And every time the company is moving outside of Russia, the thing the founders of the business think of is, should we set up offshore intermediary or European or something else, just to disguise our identity, just to disguise, make our business confidential, and so on and so forth, and especially in the US. Everybody knows that US-Russian relations are somewhat tense right now, and there is a fear from the founders that if they will... Yes?
I'm so sorry to interrupt you, but we have problems with the quality of the volume from your side. The picture is ideal, but the volume, we hear some scratches when you're speaking. Maybe you can put off your earphones and try to use the PC as itself.
Okay.
But so, let's check it, and I'll give you a backup.
Okay, how it is now? Is
At the moment, much better.
How it is now?
Okay, it's much better.
Okay. Yes. So so our advice would be to establish direct ownership over the US company. That helps to avoid a number of troubles. First of all, any intermediary would badly affect the management efficiency for the American company. Second, all the regulators in the US, all the banks adhere to the principle looking through the intermediaries. Anyway, they will be looking at the ultimate beneficiaries, they will be looking at the end shareholders, and anyway, Russian roots will come to surface. Besides, there are tax considerations. There is Russia-US double tax treaty, and it's much easier to apply its benefits to your business if you have direct links. Next point for analysis. Usually founders have two options: either to establish a parent company in United States and move to America, its headquarters, and have this company as like a holding company for the entire group. And then Russian company would be a subsidiary and establish subsidiary elsewhere in the world. And that's one option. Second option is just to retain headquarters in Russia and establish US presence just for sales purposes, probably like what Kaspersky Lab does. It always depends. Yes,
it's me again, and
okay.
We still have some problems with the quality of the volume from your side, and we have two advices from IT specialists, from Yandex and from other IT companies, because we have plenty of them at the moment, thanks to them. And what was the advice? Advice number one: switch off and switch on your micro. And if it won't help, switch off your video, because as we suppose you have a not very good wire connection at the moment. That's why it could cause such problems.
Okay.
I mean, manually switch on and switch off your micro from the PC. Now you.
Okay, for some reason.
Okay, Dmitry, try to switch on your micro and we will move forward. Microphone.
For some reason.
Yeah, I know. So let me ask Pablo to do it instead of you. He will switch off the video and switch on your microphone, and you can move on.
Okay, how it is now, Dmitry?
I can hear you.
But
So let's try. Maybe it will become better, because the piece of advice was from Yandex.
Is it better now? Should I speak louder?
Not louder, but maybe slowly. We have problems, something like a scratch. So, Dmitry, let's move on, so we don't have plenty of time.
Okay. The next point of analysis would be transfer of major intellectual property assets to US. Many of our clients would like to move their intellectual property to a jurisdiction where it will be better protected. So that's a main driving force. Maybe it's easier, as just our previous speakers told us, that maybe it's easier to patent and it here, but another point, just to be able to protect, to enforce all these protective measures. And for that reason, number of our clients are moving their IP property to the United States and have it registered for the company in the United States, not for the company in Russia. And another reason for moving intellectual property to United States is for financial purposes, because most of companies, especially startup companies, they badly need for financing. And US is a huge market, and to raise financing over there, it's much easier than Europe, than in Russia. And to have valuable assets in the company is a kind of the main condition of raising financing in the US. So if you're moving IP and put it in the balance sheet of the company, it makes it easier to raise financing. Next question, which usually founders of the company come across, which state in the United States should be used for registration of the company. And usually choice is for Delaware state. Delaware is a very well developed jurisdiction for corporate law and for legislative practice. And registration of the company with that doesn't prevent you from establishing offices elsewhere in the country, in Hawaii, in New York, in San Francisco, anywhere you want. Another point of analysis would be whether to have a Russian branch of an American company. Usually companies which are heavily involved in research and development and programming very much, they have a very much cost of employment for programmers and for researchers. And in this case, they prefer to use their Russian personnel. So if you are moving business to United States, then you would be advised to establish a Russian branch. Russian branch is not a legal entity. Branch is just a branch is a division of American company, and all the transfers between the main company and the branch viewed like inside the company. So they're free from taxation, free from VAT, free from corporate tax, and currency control restrictions do not apply because its branch is viewed like non-resident. And another reason to have a branch in Russia is that all the intellectual property developed by the branch will automatically becomes a property of American company. Last point of analysis would be IP protection rules. There are major differences in IP protection in US and in Russia. In Russia, if all the intellectual property developed by the employee for the money of the company will become immediately all owned by the company. And in US, there is no default rules. Everything is regulated by the local documentation, by internal policy, labor contract. So make sure if you establish Russia, if you establish your American presence, make sure that your protection rules are incorporated somewhere. So next slide, you can see a typical structure where US parent is set up in America, and for IP protection reasons, to raise financing and to penetrate a huge market. Here you can see a blue box branch in Russia, which will employ researchers and developers and programmers. As I said, it's very cost efficient, no corporate tax, no VAT, no currency control restrictions, and very good cost efficiency. Green boxes are just subsidiaries. American company can establish subsidiaries all over the world for sales purposes. Next slide, initial shareholder structure. It's quite typical. And as I said, no reason to set up intermediary between US parent and Russian shareholders. because anyway, US authorities would not view it as the corporate entity. Anyway, all the liabilities, all the taxes, all the income will be attributed anyway to the final shareholders. And the intermediary will make it more complicated to apply US-Russia double tax treaty. On the next slide, you can see US entry roadmap. It was developed for a few clients, and probably no reason to go step by step through the list of these bullet points. I would, just because of the timing, I would propose to move to another slide. Regulatory pitfalls. A couple of years ago, for one of our clients, we discovered a very bothering situation. United States introduced restrictions on sharing critical emerging technologies with foreign individuals. Those individuals might be shareholders, partners, employees, contractors, advisors, and 27 areas were identified by the special governmental agency in the US, technologies of which will be regulated for sharing with foreign individuals. And so before moving to US, you should make sure that your technology, which you will be patenting or registering for US company, will not fall into these categories. If your technology will fall into this category, then you may be required to report to a special governmental agency. And in case you are planning to share this technology with foreign individuals, you will be required to provide these agreements for preliminary review. And second, if the governmental agency establishes that it's critical for US, you may be required to go through the permit or licensing process. So in short, Russian shareholders who usually, founders, who usually key persons for development of these technologies, may find themselves in a situation when they will be sheltered from the technology. So they will move it to the US, have it registered for the US company, but then they will be restricted to have access to it. So this, as I said, these all the points for elaboration of our lawyers on the next conferences, and we would like you to participate them and stand by and wait for our invitation. Dmitry, any question?
Yeah, actually, I have a question for you. And before asking that question, I want to recommend to our audience to switch to Russian channel because we don't have any audio problems on the Russian channel, and the sound is perfect there. So, and what are my questions? So, first of all, I would like to ask you, so what is a better solution for Russian company to go to United States directly from Russian entity or person, or to go through, for example, offshore or European company?
Our experience indicates that going directly from Russian company to US would be more efficient for a number of reasons. Operational management of the US company would be more efficient. Tax exemptions may be applied directly. For example, if Russian shareholders will be receiving interest or royalties or maybe dividends, then all these cash flows will be exempted under the US-Russia double tax treaty. And and maybe Casey can add, because from what we hear from the Russian shareholder, they always fear that Russian roots may be aggravating their situation in US. And
We
that
have
may
plenty of samples, by the way, I would say, with our top 10 richest people who trying to act in the steel market in the United States, for example. But we are speaking not about such a huge companies. So
well, but we have a Kaspersky lab who won all the cases in the US courts. So
thanks to ZUBER LAWLER and the case personally.
So our experience indicates that direct ownership of Russian shareholders of the US company would be more efficient. That's a short answer.
So Casey, what is your opinion? Is it a problem to have a Russian root in the United States or not a problem at the moment?
I think the issue comes down to how the company will be run in the United States and how much control or direction will be coming from outside. If the company will be run essentially from the United States with employees here, perhaps yes, that's the place to be. But there are situations where maybe that's not the case. I also know from speaking to Dmitry that this is an area that changes a lot and has changed a lot in the last 5 years. So I think that I would defer to the expert on this question only because from what I see, there are changes happening all the time. And it's always good to have the latest information.
So thank you, Casey, and thanks a lot, Dmitry. So we are at the end of our webinar, so we shared everything we prepared for today. So I would ask all these panelists to appear again to say goodbye and to say, first of all, thank you to all of you guys. As for me, the information was very interesting and very useful. Even for me, the guy in IP, something was really new. And thank you everybody. Thank you, Casey and Casey.
Yes, I would like to thank all of our panelists for your presentations, and also our interpreter for a good job on the Russian channel. And I would also not to forget our sponsors, Yandex, Kaspersky Lab, Skolkovo, Transaction Advisory Group, of course, PATENTUS, and last, ZUBER LAWLER.
Thank you.
Thank you very much. Thank you for the invitation. It was a pleasure.
Thank you. Thank you very much.
Have a nice weekend, all of you panelists, all of our audience, and be healthy and all the best. See you on our next webinar in a couple of weeks. Goodbye.
Thank you. Bye.